A school of Islamic law is not a sect. It is an institution based on scientific foundations. A school comes into being when a group of jurists, usually students of a well-known teacher, start adopting certain fundamental presumptions about the Quran and the Sunnah, and when they start adopting uniform principles or rules of interpretation for the Quran and the Sunnah. The first fundamental presumption is that the Quran is a source of Islamic law. The second presumption is that the Sunnah is a source of law. The list goes on. The first rule of interpretation will be that whenever a command is found in a text of the source, it will give rise to mandatory law. Other rules may decide as to when and in what situations the law is to be applied, how many persons are covered by the rule, and who will be exempted from the application of the law. The sources of law accepted may be a dozen or more, and the rules of interpretation may run into hundreds. Knowledge of these sources and the rules of interpretation constitutes the discipline of usool al-fiqh, or expertise in the principles with the help of which the law will be derived and applied. When these rules are relatively settled, the school is well on its way and may be said to be established. The adoption of the presumptions and the principles is almost always attributed to the founder or teacher. Although their development was actually a team effort, the school, therefore, takes its name from the teacher. The presumptions and principles of interpretation are used to derive and develop the law. In fact, the development of the principles of interpretation does not precede the development of the law. They go hand in hand and are developed and refined simultaneously. The law or fiqh, however, follows a different pattern of development. It is usual for the layman to ask the jurist a question and seek a response. But in this case, it is the jurist who raises an issue by describing a somewhat complex fact situation that needs a legal solution. These facts may have been derived from a real solution, or the case may be a hypothetical designed by the jurist. Hypotheticals are used in the law even today, and many of the cases used for classroom instruction may be hypotheticals. Roscoe Pound, dean of Harvard Law School for a long time, when faced with a text of the Hidayah for the first time, remarked that this was the beginning of the case method that is used in law schools and business studies today. The issue framed in the form of a case was presented by the teacher, and then the students were asked to respond. As we derive most of this information from the Hanafi school, as it was the first school of Islamic law to be born, it becomes easier to explain things by using it as an example. Abu Hanifa was born in the year 80 of the Hijrah. If he started teaching at the age of 40, then it would be the year 120 of the Hijrah, when the framing of such actual cases and hypotheticals began. The process continued for the next 10 or more years. However, the law attained maturity by the year 132 when the Abbasid rule began. The teacher would present the case, and the students, who were jurists in their own right, would give their solution or opinion, sometimes agreeing with the teacher and disagreeing with him at other times. The cases and hypotheticals so framed, along with multiple solutions, ran into tens of thousands by this time. Abu Hanifa died in the year 150 of the Hijrah, and it was at this time that Muhammad Shaybani, his worthy student, began recording this huge body of law. His works, completed before the year 180 of the Hijrah, ran into many volumes, and they still form the foundation of Islamic law, not only for the Hanafi school, but also as source law for many other schools. This period was followed by that of jurists who started giving greater system to the recorded law by classifying the rules under their relevant heads or categories. In addition to this, the rules of interpretation were also recorded and reduced to a topical arrangement. A number of new fields were also developed, like legal maxims, the discipline of distinctions or faruq, and even the discipline of the objectives of the Sharia. Many commentaries were also written. The most important work undertaken by jurists in this period was the verification of the narrations about the legal opinions coming down from the earlier masters. The verification, undertaken and processed, led to the statement of the law preferred and adopted by the Hanafi school. The process led to the preparation of précis, or summaries of what the law of the school was, which in turn led to the approved statement of the entire body of law. It is pertinent to mention here that the law is not the opinion of a particular jurist, but the law that is approved and adopted by the school. Opinions of individual jurists do not matter once approval has been granted by the school. They merely have instructional value. The précis or mukhtasars so prepared reflected this law. The process of preparing précis, writing commentaries and adding glosses on them continued for the next several centuries. But the law approved by the school could always be identified separately from the commentaries, explanations, and glosses. During and after the age of colonization, this important separation between the law approved by the school and opinions of individual jurists contained in the commentaries disappeared. Ignorant publishers, who knew very little about the system within Islamic law, merged the approved law with the commentaries and glosses, removing all distinctions, which could now be deciphered only by the elect. The result was that even the specialized schools, or madhabs, forgot these distinctions. Modern universities followed suit, and professors attempted to teach the opinions of individual jurists rather than the approved law of the school. When faced with the need to decide what the law was, they would randomly select one of the opinions as the most suitable for qualifying as law. This was something that the schools had already done, and these professors neither had the expertise nor the authority to prefer one opinion as the preferred law. For the student, it resulted in bewilderment and confusion, for he did not know what kind of legal system he was studying, a system that had many candidates for becoming the law. Had all this been done intentionally to undermine the Islamic legal system and to demolish the architecture so carefully planned by the earlier jurists over centuries? We cannot say. Related to the confusion of understanding opinions was the desire to break out of the hold of individual schools. Modern scholars, probably driven by the desire to become great jurists, decided to jump over school boundaries in their search for a suitable law for modern problems. If one opinion could be preferred within a school, why not widen the choice and include the opinions from other schools as well? Thus, Islamic law became a matter of pick and choose rather than academic or juristic expertise. One banker commented that if it was that easy to become a legal scholar, even he could do the job with ease. The truth is that the opinions of each school are based on independent systems of interpretation. These interpretation systems may appear similar, but in reality, they are independent and unique. It is not possible to move across schools in search of opinions. Others, who are not even aware of these unique systems of interpretation, have assumed that it is merely a matter of knowing Arabic. Such people are reading traditions from the internet today and spreading their views as if they were the law. May Allah have mercy on us.